This is the current federal tax developments for the week of February the 13th, 2017. Current federal tax developments are brought to you by Nichols Patrick CPE, a division of the Lascalzo Institute, and your state society of CPAs. And this week, we're taking a look at the fact that the tax law can be unfair. And we'll look at the following developments in this case. First, we're going to take a look at the fact that the IRS was not bound by the fact that it had previously told a taxpayer for 3 straight years that essentially he could treat his distributions as non-taxable on military pension. 4th year decision changed. The tax court, in a decision the taxpayer probably found fair, decided that we did not have to treat an interest in a defined benefit pension plan as an asset in computing the taxpayer's insolvency. The tax court, in what was really an interesting decision, where the court itself admitted the result was unfair, nevertheless denied an exemption for grandchildren to a taxpayer who essentially was paying for all the kids' work because her son was, somewhat less than responsible and apparently somewhat less than honest. We had a husband that discovered that his wife, who believed that she needed to file a separate return to claim a loss from the Madoff securities scandal in 2008, even though she had never invested with Madoff securities. He thought maybe she wasn't quite all there for purposes of filing a return. He wanted to file a joint return. Turns out the court will tell us he couldn't do so. The IRS this week gave us a little bit of a present. They gave us an extra month on extensions for calendar year C corporations, or what they really did was clarified that they really meant what they said when they published instructions and publications in December, that many people thought, they just forgot the law changed. Turns out they didn't. And finally, we have a case dealing with preparers' due diligence, or more appropriately, lack of due diligence, with regard to a claim for an earned income credit. This one will be important because remember, the due diligence rules this year expand beyond the earned income tax credit to take a look at the child tax credit and the American Opportunities Tax Credit. Well, we're getting close and we're into tax season, and we're coming up on the time where we're going to start getting to where we just kind of put our heads down and don't really end up doing a lot of things in this realm, or at least all the time, shall we say, in CPE. But we do still have time for a couple of update courses coming up. I want to remind you that Butch Olson's updates for industry will be taking place February 17th and February 24th in Ohio. The 17th will be a live session in the Cleveland area, actually in Independence, and the February 24th will be a live session in Columbus at the society offices, and that will also be webcast. So if you're in either the Cleveland or Columbus area, or you want to pick up the webcast, check the Ohio Society of CPAs website. I'm also scheduled at the end of this month to go to Beaverton, Oregon, which is just outside of Portland, Oregon, and do another 8-hour update, this time business and industry tax update. This is, again, like Butch's course, this is aimed at CPAs and industry, because we always know there's that problem this time of year that those of you in industry tend to feel like everything shuts down for continuing education. And once you've got your books closed out for the year, it's, I would like to go ahead and take some courses now at this time. Might not be a bad time to do it. There seems to be maybe you feel less available, especially in the tax area. So this is an attempt for us to add some of that. So any of you in the Beaverton area, or I should say the Portland, Oregon general area, want to come up there and take the course. That'll be at the Society's offices in Beaverton, scheduled for February the 28th. So we look forward to seeing you at either in Ohio or in Oregon to talk about industry-related tax updates. Now let's get to our cases for this week and our developments. And we're going to start out with a case of Taylor versus Commissioner. The case of Taylor, Mr. Taylor was a retired military veteran, and he had retired from the Army after completing the length of service necessary to qualify for retirement in 2002. He did not separate due to disability, he simply completed the time necessary to have your standard service-related retirement. He did, however, file an application with the Veterans Administration for compensation for service-related disabilities. He was awarded partial compensation for such disabilities, and he's paid that by VA, who does not report that on a Form 1099-R. But he had talked to other members of the military and had determined that, he believed he should be able to treat part of his regular retirement pay as being excludable from his income for disability-related purposes, so he shouldn't have to pay tax on the entire amount that was being reported as taxable by the military on the Form 1099-R. So he filed actually 3 amended returns. The IRS paid back, gave him a refund on all 3 of those returns. However, when he later filed his 2010 return, attaching a same worksheet, same position, same information he had on those 3 amended returns, the IRS basically decided to disallow those deductions after he examined them and claimed it was taxable. Now, Mr. Taylor eventually conceded that he was mistaken in believing that those amounts should not be taxed, but he said the IRS should be bound by the fact that they had misled him for 3 years, and therefore they were bound to continue to allow him to take the deduction. Well, the tax court looked at it and said basically the issue here is he's claiming a defense called estoppel, specifically equitable estoppel. And that's a judicial rule that, as the court explains in its opinion, that precludes a party from denying his or her own acts of representation which induced another to act to his detriment. Now, unfortunately, it's very difficult to carry an equitable estoppel claim in the area of federal taxes. It's going to be very, very difficult, as the court noted, to carry it in the case of a case against U.S. government. You have to show that there was a representation that, in essence, that they must establish there was conduct constituting a representation of material fact, there was an actual or imputed knowledge of such fact by the party representing it, there was an ignorance of such fact by the representee, which in this case would be the taxpayer, and the actual or imputed expectation by the representor that the representee will act in reliance upon the representation and actual reliance detriment on part of the representee. The court said, well, that's a wonderful set of requirements, but here's the problem. It starts with a misrepresentation of a material fact. And in this case, they said the problem was the IRS didn't make a mistake of fact, they made a mistake of law. A mistake of law does not qualify for this particular exclusion. They accepted the amended returns, they made a mistake of law, they gave him a refund, but that does not stop the IRS from changing the position on a later return. Now, probably if you went further down the line, the other problem is, he supposedly took action in reliance upon that. Well, there wasn't really any action he took except for not paying the tax that he should have paid. It wasn't as if he took an action that somehow disadvantaged him totally. So effectively, while it probably will help him, and did help him in this case, in getting out of penalties for the underpayment of the tax, it's not going to help him in terms of not having to pay the tax. Next up, we're going to take a look now at the case of Schreiber versus Commissioner. This is Tax Court Memorandum Decision 2017-32. It came out on February the 9th of 2017. I've talked to a few people. You'd think by now that we would have washed out all the problems from the real estate crash in the late 2000s, but I've talked with a few other practitioners, and we're still seeing some of these continue to come at us. So these issues are still kind of interesting. We are now seeing the litigation come out of cases that came up during those years. This is a case, Schreiber versus Commissioner, that arose from the real estate crash that took place in California. It's a California case. And the taxpayers in this case had cancellation of debt of $448,671. It was debt secured by a piece of property that was not their principal residence. In this case, the taxpayers had excluded part of that cancellation of debt income from their income by arguing that they were insolvent. The actual computation of insolvency was in dispute between the IRS and the taxpayers, and actually the taxpayers conceded that values on some of their property were different than what they had on their return. So there was no question there was going to be some tax owed. But there was a fundamental issue that was in play here. The taxpayer in this case was a former law enforcement individual who is being paid a pension by the state of California under the California Public Employees Retirement System, or CalPERS. The IRS was looking at this. He was receiving a payment of over $5,000 per month. That was his pension right. It was a joint survivor pension, so if he died, his spouse would continue to receive it. The IRS claimed that, you have to count the value of that pension, and obviously that's a valuable asset, that you had to count that in calculating your insolvency. The taxpayers said, wait a minute, we actually have no rights, we have very few rights whatsoever under those plans. All we had the right to do is receive the monthly payment. The taxpayers were barred under the plan from converting their right to a lump sum amount. They could not assign their interest to a third party. They couldn't sell the interest to a third party. They couldn't even borrow against the interest or directly from the plan. So they're saying we had no way to access this money in order to pay off the debt. So we have no practical way to get this money except to live. And because of that, we shouldn't be treated with, have to pick that up as an asset for calculating insolvency. The tax court said, well, we have to take a look at this because the code doesn't really define what assets are for insolvency. They went back to the case of Carlson versus Commissioner. That's under 116 TC 87, a 2001 case. And they determined that the issue there was whether we have to consider something as an asset. It might not be available to creditors under bankruptcy. It still needs to be considered. But the key issue here is, in the Carlson case, the court had decided that the taxpayers could have cashed in the asset, paid an immediate tax on the income, and then had amounts available to pay the debt. The concept of that was they looked at the fact under Section 108, if we do have insolvency, we reduce the basis of assets, and therefore, at some point in the future, theoretically, we're going to pay more tax. Maybe we get less depreciation, maybe we get a larger gain on sale, a smaller loss on sale, but effectively, to at least some extent, in some cases to the entire extent, a cancellation of a debt exclusion really for the insolvency exclusion is more of a delay in paying the tax. The court decided that was significant. And they said in this case, the taxpayers had no right to be able to sell or convert that into cash and pay tax on immediately. Because of that, the court found that this particular CalPERS interest was not to be counted as an asset in computing insolvency. I will direct your attention, though, to a 2012 case of Shepard versus Commissioner, TC Memo Case 2012-212, where the court did include the value of a defined benefit plan, or at least suggested you had to include a value. And in that case, they suggested the value had to be at least what you could borrow from the plan. Now, that's not technically what could have been converted to cash and paid tax on immediately, which was the test that this court discussed. But it does suggest that it may be crucial to distinguish between Shepard and the Schreiber case. The issue that in Shepard, they had the right to borrow. In Schreiber, there is no right to borrow. The answer is not clear looking at these two cases, but it does appear that if you have a taxpayer who's trying for an insolvency exception, they have a right in a defined benefit plan, you may want to get every detail you can about all rights the taxpayer has under the plan, especially any right that they might have to borrow under the plan, because it appears from these two cases that that is somewhat significant. Now going on to the fact that life just isn't fair. The case of Smythe versus Commissioner, Tax Court Memorandum Decision 2017-29, issued on February the 7th. In this case, the tax court states up front, the just result in this case would have been to allow Ms. Smythe to retain the claim of the exemption for her grandchildren. She maintained a household for herself, her son, her son's wife, and the grandchildren. Her son had drug problems, apparently, is what we've been told. The wife was not currently working a job. Apparently, the only person earning any money in this case was Ms. Smythe. And she was paying for the entire household. She paid for all the kids, all the kids' expenses. She took care of all those problems, and she wasn't making that much money. Okay. In this case, her son, when the time came for Ms. Smythe to file her tax return, her son told her that he and his wife were not going to claim the children on their return. Now, under the rules that we have for qualifying children, generally the parents have the first right to claim. But if the parents do not claim the child as a qualifying child, and the children, another party will be able to treat them as a qualifying child, and that party has greater income, which Ms. Smythe did, than the parents, then she can do so, but it is all required that the parents do not claim the child. So Ms. Smythe did that, got a refund because she qualified for the earned income credit, qualified for the additional child tax credit. So she got a refund, and she got the exemptions for the kids. However, a little while later, she got a letter from the IRS that essentially ended up resulting in a tax bill to her of over $5,000, which is essentially what she got refunded, plus the real tax she might have owed with having no dependents. The tax court said, well, she went back. Her son initially denied that he had actually claimed the kids, but then eventually he agreed to prepare an amended return that would release the kids. Well, the amended return was prepared just before the trial, and they handed the amended return to counsel for the IRS. Now, the tax court said, well, on paper, unfortunately, the law here is simply unfair. Your son may have lied to you. He may have taken it, and the mother thinks he used it for drug money. So he may have used it to go buy drugs, but like it or not, he had a right to claim the kids, and if he claimed them, it's going to shut the grandmother out. Well, what about the amended return? Now we get to another piece of unfairness. The problem is you can't just hand an amended return to any IRS employee. It must be filed in accordance with the rules. And according to Section 1691, you have to file it with the Internal Revenue District in which you reside, or at the service center, or with individuals designated to receive the return. Counsel for the IRS in a tax court case is not a person assigned a responsibility to receive a hand-carried return. Because of that, the amended return was not considered filed. And because of that, now we get to the truly unfair result. She basically owes the $5,000 back to the IRS. Unfair, yes, but nevertheless, what the law demanded in the view of the court. Moss versus Commissioner, Tax Court Memorandum Decision 2017-30, issued on February the 8th, is another case where things got a little out of hand among members of the family. Well, we have an issue here. Mr. Moss, his wife had suffered from mental illness in the past, had been actually hospitalized in the past for it. In 2008, basically in 2009, came time to file their joint return for 2008. But Mrs. Moss had been reading, and hearing things on television about Bernie Madoff, and about people could get in it. Basically, that Bernie Madoff, a special tax rule was put in place to allow people to claim deductions for their losses from Bernie. Despite the fact that Mrs. Moss had never had an investment with Bernie Madoff, and despite the fact that her husband kind of, kept telling her that, no, you have no right to this, she insisted in believing that was true, and she also insisted in believing that she had to file a separate return for this to happen. Now, Mr. Moss filed a return with the IRS. He sent a letter along with the return stating that effectively that, he was filing on her behalf, and they really should ignore any letters that she sent because she was, basically, he said she's seriously mentally ill, and, all of her income and his were on the return, and this is the one they should do, and really, they shouldn't really pay attention. Mrs. Moss did prepare a separate return, which, by the way, is interesting in how it was done. She claimed this huge Madoff loss, but then only flowed $9,000 of it to Schedule A, which is kind of a random number. Also had a few other kind of random numbers on the return. The IRS did accept Mrs. Moss's return. They corrected it for the amounts they had, and there was tax assessed against her. Now we go to court. Here's the problem. Generally, there are only very few cases where a joint return can be filed where only one spouse signs it. Either the spouse has to act as an authorized agent for the other spouse, or there must be or you must show that the spouse consented, the non-signing spouse consented to that. Now, basically, here's what we need. We need in this case that if you're going to have this to be an authorized agent, there's regulation 1.6012-1A5. These provisions require that such a return be accompanied by a power of attorney form, right? Form 2848, which he didn't have. It has to have a statement signed by the spouse who has signed the return confirming that the incapacitated spouse consents to the signing of the return. Well, no, he sent a notice stating she doesn't consent to it. He told them that. Or a request for permission from a determination made by appropriate IRS district director that good cause exists for the agent to submit the return. He didn't really ask for that permission and receive it before filing the return. He never showed that she was not competent to file a return. Now, the fact that she had mental illness in the past and been hospitalized, and the fact that a number of years later she was committed, or not committed, but she had a conservatorship appointed for her. Her daughters were appointed conservators for her. That doesn't prove that she wasn't able to file in the year in question. And the court said even if she wasn't able to file, it doesn't show that he was the authorized parties, as they pointed out. When a conservator was appointed, it was the daughters, not the husband. Now, the husband said he didn't go for conservatorship because he was trying to keep peace in the family, which probably he was. I suspect his wife would not have liked a conservatorship, and where he was in charge of it, that would have been a problem. But the reality is that he had not fulfilled the requirement. He had not shown he needed a conservatorship, and the fact that she was, kind of being erratic wasn't enough to show that she was not authorized to withhold her consent to a joint return, which she did. Good news next up. Well, it's news the IRS gave us in December, but most of us had trouble believing it. So we finally got confirmation this week. The IRS published revised instructions to the Form 7004, and they put a posting on their website that was entitled 6-Month Extension Period for Calendar Year C Corporations. And that was posted on February the 8th. Under the Surface Transportation and Veterans Healthcare Choice Act, Improvement Act, I should say, of 2015, the Congress had said that the due date for C Corps was going to be now the 15th day of the 4th month after year end. Okay, that's fine. So that would make calendar year C Corp due on April the 15th. But because of the federal budget issues and the fact that the fiscal year ends on September 30th, there had been a special rule that for 10 years said a C corporation would only get a 5-month extension to file its return, while other C Corps, except June 30 C Corps, would get a 6-month extension. Now, you want to know about that June 30, let's go to that aside for just a second. June 30 C Corps, their due date is not the 4th month, because again, that would take it from September to October. So they have a due date that stays at September 15th, but they get a 7-month extension. Now we move forward. The IRS published the 7004s for this year, instructions, and they published publications related to that for corporations and filing returns. And that information suggested that you got a 6-month extension unless you were a June 30 C Corp. Well, everybody said, wait, the law said that, that calendar year C Corps don't get a 7-month extension. So that's just a misprint, IRS. Well, the IRS, after letting set here for over a month, issued this notice, said, no, that's not a misprint. While 6081B added by the Act provided for that 5-month extension, Congress did not repeal Section 6081A, which allows the taxpayer, the IRS, to grant an extension of up to 6 months to file the return. Now, that's discretionary. So while the law required them to grant a 5-month extension at a minimum, now invoking their right under 6081A, the IRS is now going to allow a 6-month extension for your C corporation calendar year Cs. That's probably going to confuse things a bit, because I'm sure a lot of you updated your tickler systems or whatever type of system you have for tracking due dates to make the due dates for the extended due dates for calendar year Cs to be September 15th. Now you got to go back, remember, to change those and say, no, it's going to be October 15th, will be it. So the original due date will be April 15th. The extended due date will be October 15th. Finally, we have the case of Fox versus Commissioner. In the Fox case, this was a United States Court of Federal Claims case number 1:15-CV-01266, issued on February 7th. Mr. Fox was assessed a preparer penalty for gross negligence under 6694 for willful or reckless conduct. That means they claimed he prepared a refund or claim, a return or claim for refund, which he did. There exists in our statement of tax, which, as we'll determine, there was. And number three, this is the problem. The underpayment was due to conduct that was a willful attempt to understate the liability or a reckless or intentional disregard. Now, what happened is a bit in dispute between Mr. Fox and his client. According to the client, she brought in her W-2 to Mr. Fox, which had total income of $15 for the year, no other income on the return. Well, obviously, she didn't need to really file. And number two, she wasn't going to get much of a refund. She might get back if they withheld $1, she might get that back. That'd be it. Now, she and a friend she brought along, who was there with her when she brought her return in, testified that Dr. Fox, who is the tax preparer in this case, he told her that if she had business income, he could get her a really big refund, obviously talking about the refundable earned income credit. Now, she then went out the same day, got a business license, applied for and obtained a business license, then came back to his office. They prepared a return that showed a business that she had, supposedly had, that had $18,000 of income. The question becomes, okay, where did that $18,000 of income come from? And did Dr. Fox know she didn't have a business? Now, she and her friend testified that Dr. Fox essentially told them to go get the license, effectively, and that Dr. Fox had basically just put a number on there for income, and the taxpayer had never actually given him that number. The preparer, Dr. Fox, claims the opposite. He claims that she told him that she had this business and had $18,000 of income. The IRS assessed Dr. Fox a penalty after they examined this woman's return and discovered there was no such business, never had been. So they took back the earned income credit, and now they're coming after Dr. Fox. Now, Dr. Fox claims he reasonably relied on the statement of the client. The Court of Claims came back and said, well, okay, there is some question, and it appears the court had a little trouble believing, the court seemed to suspect that Dr. Fox might have been the source of this. We had the testimony for that, but they said, we don't really care. It doesn't matter. Even if the client had told Dr. Fox that she had $18,000 of income, because of the earned income credit and the due diligence rules that apply to the earned income credit that applied to the earned question, Dr. Fox needed to make more significant inquiries about the nature and actual existence of that business rather than simply accepting the client's word for it. Since he did not make any additional inquiries or make any other checks into that, he was not allowed to simply accept the taxpayer's word that they had this much income from the business and claim the earned income credit. Therefore, the court sustained the IRS's penalties. Now, this is an issue for us because remember, for 2016 returns, we now expand the due diligence rules generally to cover the child tax credit and to cover the American Opportunity Credit. Now, the regulations that were published in December, the temporary regulations, tell us that we generally can rely on what taxpayers tell us. We have to make inquiries of it. But this case suggests that there may be issues of having to look a bit further into information that's given to you. By the way, so do the regs. It's not a perfect defense to say the client told me they had this much income. Rather, or they told me they had the right to claim the child. You need to make specific inquiries, and if you have reason to doubt, you have to follow up. Well, it's Valentine's Day is coming up, so hopefully you didn't forget that for this week. If you're listening to this after Tuesday and you didn't realize it was Valentine's Day, you may be in a bit of hot water. Just want to warn you about that. If not, you're listening on Monday or before Monday, because we'll post this in the weekend. Remember, you still got some time to get something. It's also, that means Valentine's Day means it's almost February 15th. And that means the brokers consolidated 1099s are coming out. So I know a lot of you are in public accounting and do tax work. You're going to get rather busy, not going to think a lot about CPE. We in your state societies, though, just want you to remember to consider when you come up for air after tax season, remember your state society's continuing education. Also remember, if you do need to bone up on something during tax season because you got a problem, an issue arises, almost all the state societies have arrangements where they have deals or arrangements, and where you get some benefits or you get reduced price on self-study programs from various vendors. So be sure to take a look for your offers there if you're a member of a state society. This has been the current federal tax developments for the week of February the 13th, 2017. Be sure to catch our daily updates or regular updates on the website currentfederaltaxdevelopments.com. You can also go there and on our weekly updates page, click there, download a PDF with all of the topics and the articles for this week. If you have any questions or comments, send them to me, Ed Zollers at currentfederaltaxdevelopments.com. You can also follow me on Twitter. I can be found at Ed Zollers. Hopefully you have a good week this week. Those 1099s start coming in and you start actually being able to finish up on clients who have brokerage accounts, which usually is a majority of our clients. And we look forward to seeing you next week as we'll talk about developments in the upcoming week in the area of federal taxes.